So thank you very much, sir. So actually, before I respond to the discussion points, these are the kind of bills on which the opposition should actually take interest and participate, sir. These are very reformatory. These are going to help the country to move forward fast. And these are steps on which no one can have a difference of opinion, except if they want to suggest improvements on it. So it's such a sad state, sir, that our opposition chooses to walk out on these kind of important debates. So you may remember, sir, Honorable Prime Minister, speaking from the Red Fort, had very clearly called for change in the mindset that is so required. He spoke about the Panch Pran, and one of the things that he had highlighted was get over the colonial mindset. So in keeping with that, I recall our senior member, Arun Singh Ji, also spoke about the number of laws that have been changed, number of regulations which have been simplified, and that helps in ease of doing business. But keeping in line with the Honorable Prime Minister's advice that all the colonial laws which were written for the subjects of the Queen or the King will have to now be changed so that we give ourselves a citizen-centric facilitating act rather than one for the subjects of a royalty or the imperial force. So in that light, when we looked at the Bankers' Books Evidence Bill, it is 1891 of origin. So also the way in which it had included instruments related to banking which were relevant for that period, which were largely paper-based. Whereas India has shown exemplary speed in digitizing its economy. So the instruments with which you are able to do your banking activities, your financial transactions, have all now become so phone-driven. Each customer or each bank business holder is in a position to do everything that they want to do with a simple button pressing in the phone itself. So the related aspects of doing business through a bank, commercial operations, also will have to catch up with that kind of a digitization in the financial inclusion area, financial sector. Therefore, the Bankers' Books Evidence Act in 1891, which was a legislation which was paper-based, as I said, and everything depended on certified copies of bank records as evidence in legal proceedings. So if somebody had a problem transacting money from one account to another and there was a legal dispute, the bank is not a party, but even then the bankers are called to appear before the court. Or the bankers are asked to appear before the court with papers of the original transaction and so on, which also has a problem of privacy. However, at that time in 1891, this was used for legal proceedings also. But with the advent of digital and electronic record keeping, there was a necessity for bankers to be given the power to say, why not the certified copies in the courts rather than get the electronic records, which is sheer impossible. You're carrying a system, even the system which can come on your phone is not accepted as otherwise based on the 1891 Act. Therefore, the Bankers' Book Evidence Act 2026, Evidence Bill 2026 is being brought before this House. We seek to repeal and replace the Bankers' Book Evidence Act of 1891. Just for a moment, sir, to say, is this allowed by law? Yes, it is allowed by law because entry 45 in the Union list, which is the list 1 of the 7th schedule to the Constitution, empowers the Parliament to repeal and re-enact an act. We are invoking that and repealing the 1891 Act and bringing in the Bankers' Evidence Bill, Bankers' Books Evidence Bill of 2026, which will replace the repealed 1891 Act. So the bill, among various other things that it wants to do, provides for provides for a technology neutral legal framework for bankers' books. It recognizes electronic and digital banking records. It standardizes the certification process, facilitates the admissibility of electronic banking records. It permits authentication through manual, digital, and electronic signatures. It also, therefore, strengthens the statutory protection available to the bank officers where the bank is not a party to the proceedings by requiring the court to record the existence of a special clause, which is the feature in this new one. It suggests to the court to record the existence of a special clause before summoning them, or invoke a cause which is specialized for summoning them, empowers the central government to extend the applicability of the Act to specified financial sector entities, and also aligns the law with the contemporary banking practices. Sir, this particular Act has about 16 clauses which provides for several specific provisions, all of which will allow for the digital records to be in the form of a certified copy, which can be admitted in the court of law. I highlight a few things. Explicit legal recognition is going to be provided if this House passes this passes this bill as an act. So explicit legal recognition of electronic records. So this particular clause provides that electronic or digital records of bankers' books shall be admissible, it shall be valid and legally enforceable as evidence, subject to the conditions specified under the Act. So clauses 6 and 7 relate to that. Expanded definition of bankers' books is being brought in now. It expands the definition of bankers' books to include records maintained in written or physical form, or stored in electronic or digital form, or otherwise, either on-site or at off-site or virtual or cloud location, including backup or disaster recovery site. So that is the clause 2(1)(b), which we are bringing in now. Conditions for admissibility of electronic or digital records prescribes this Act will prescribe, once passed, the conditions to be satisfied for the admissibility, validity, enforceability of electronic and digital records of bankers' books as evidence, with an enabling provision for the central government to notify such other conditions. Standardized certificates can also be prescribed. So this Act prescribes separate certificate formats for certified copies of bankers' books maintained in written or physical form, or in electronic or digital form, as specified in the first schedule and the second schedule respectively. So again, the central government may by notification modify the certificates and specify in the rules. This is clause 3 and clause 12 read with the first schedule and the second schedule of the Act, sir. So this Act also will define the expression special cause, which I mentioned when I opened up the remarks. The special cause will be a part of this bill if passed as an Act. It will give the basis for summoning a bank officer to produce bankers' books or appear as a witness in legal proceedings to which the bank is not a party. There can be a case where two people are fighting, commercial case, the bank is not even a party. Today they're all being asked to come and stand before the court, which is their duty, they will do it. But is there a reason why they should be called in a dispute which is not involving the bank at all? So we are now giving a clause through which a special cause can be invoked by the courts, whereupon they can ask the bank to come and appear, even if it's not a party. And therefore, there, the evidence and everything, even if they're electronic, can be taken and that can be made applicable. Sir, so the special cause can be invoked. I also, in this context, understand, and also the points which I mentioned a bit earlier, appreciate the point made by Sri Niranjan Reddy of the YSRCP about can there be a committee which therefore authorizes instead of the, every time the government having to come to the parliament. Whilst I appreciate the point made, more than the ease which provides it for the government will not hesitate to come before the House to seek their approval and be accountable to the House. So the point which you have made is well taken, Honourable Member, but I would like to assure that the government will be happy to come and stand before the House to explain. So I think, sir, largely every member has spoken understanding the importance of this act, which is being brought in this context. I particularly thank Sri Rajendra Jain of the NCP, who appreciated the digitization efforts which are being undertaken, and therefore an act of this nature is important, and also for his extending his party's support. Similarly, Sri Vaddiraju Garu from the BRS for supporting this bill. I also thank DMDK's member Sudesh, also extending the support, and Shiv Sena's Jyoti Vagmareji for also extending her support for this bill. I particularly thank senior member Sri Thambiduraiji for taking this whole thing in a very positive context to see the importance of such amendments which are continuously being undertaken by our government. So I thank Sri Thambiduraiji, particularly when he speaks about the cyber security related aspects, and TDP's Bhashyam Ramakrishnaji, who's a new member, but who has spoken about the importance of digital amendments which are coming through. So there is just one point which I want to highlight. Member Dhanapal of AIADMK seeks clarification on clause 4 to extend the provision to other financial sector entities. So the banking and financial sector has evolved significantly in this country over the past few decades, with the emergence of NBFCs, payment aggregators, fintech companies, and other service providers having a pan-India presence. These entities perform an important role, sir, in fulfilling the banking and financial needs of the common people. So it is therefore necessary that whenever and wherever required, they are provided a similar evidential framework. This, therefore, clause 4 enables the central government to act and to extend the act to other regulated financial entities through notification, ensuring that uniform evidentiary framework across all the financial sector is available. So Sri Manas Ranjanji from BJD also spoke of data security, privacy to be given highest priority, also spoke about authenticity of electronic records for courts, and that we should strengthen public confidence. So the bill permits banking records to be produced either in physical or electronic form, as the case may be. So that is already being enabled through this new bill which is coming. The bill actually strengthens public confidence by providing a clear, secure, and transparent legal framework for the use of banking records in legal proceedings, while fully safeguarding the privacy and the confidentiality of customers. So largely, I think I've addressed most of the concerns of members. In case I've missed out on anything, I'm sorry, I can always meet them in person and talk about it. So I'm grateful that you've given me an opportunity to reply for the debate.
Honorable members, the question is that the bankers Books Evidence Bill 2026 as passed by Lok Sabha be taken into consideration. Those in favor will please say aye. Aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. The motion is adopted. We shall now take up clause by clause consideration of the bill. Clause 2 stands part of the bill. Those in favor will please say aye. Aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. Clause 2 is adopted. Clause 3 stands part of the bill. There is one amendment. Number 6 by Dr. V. Shivadasan. Dr. V. Shivadasan, not present. I shall now put clause 3 to vote. Those in favor will please say aye. Aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. Clause 3 is adopted. Clause 4 stands part of the bill. There are two amendments. Number 1 by Dr. John Britas. Are you moving the amendment?
No, sir.
Moving? No. Not moving.
I understand that, yeah.
Not moving. Dr. V. Sivadasan, number 7 by Dr. V. Sivadasan, not present. Amendments, not moved. I shall now put clause 4 to vote. Those in favor will please say